who is a leader for the Labor and Employment Practice Group here at Butler Snow. Kara has graciously been working with several groups across Tennessee in order to kind of talk with them and help walk them through these new kind of overtime regulations. So Kara, thank you so much for joining us and sharing information with our partners. So over to you.
Thank you, Natalie. I appreciate your kind introduction, and I'm happy to visit with you all today and go over these upcoming changes in the law. Just a little bit about who I am and where I'm coming from on this. I'm an employment attorney. I do only employment law matters, only for the employer or company side. I'm located here in Nashville, but I represent clients all over the state. We actually have an office in Memphis, which is where I am from originally. And so I saw a lot of names popping up from West Tennessee. So shout out to you guys in the West as well as everyone else. What I do is on a daily basis, I counsel and advise clients on compliance with applicable employment law, including the wage and hour law that we're going to talk about today. I also do defense of employment disputes, lawsuits, litigation, and agency charges, which is not where you want to be. You want to avoid that situation. And so if you are keeping up with your compliance, you're a lot less likely to end up in that situation, which is one of the reasons why we're here today, to help you be in compliance. And thank you very much for having me. I did want to give a quick caveat at the beginning. This is a general presentation. I'm going to give you an overview of this law, what it means and what is changing, as well as an update. Kevin mentioned there was a lawsuit filed last week to try and strike this new law down. So I'll tell you what I know about that. And I'm going to try and save some questions at the end, time that is for questions at the end, and I'm happy to take questions. I can't get into anything real specific. This is not legal advice. It's not specific to anybody's situation. I can give general overview of what the law is and what you need to know. But if you need specific legal advice, you do need to contact an employment attorney. Butler Snow is happy to help. There's a lot of other great law firms out there. Some of you may even have in-house counsel that can help. So with that, let us move forward. And Natalie's going to move the slides today. Thank you for that, Natalie. All right, so people get excited when something changes and they want to know about the change. But for this particular law, I think it's really, really important for everyone to have a refresher on what the basic underlying law is that's changing. Most of the businesses I encounter, including all kinds of businesses in all kinds of industries, including nonprofits, they could always use a refresher on wage and hour law generally. And so I'm going to give you a little bit of that, which will help you understand what this change would do and how it fits in to the overall compliance and regulatory framework for wage and hour issues. So the law that is changing and the law we're going to talk about today is the Fair Labor Standards Act. I call it the FLSA. It is a federal law. It applies virtually universally. You don't have to have a certain number of employees to fall under this law. There are some very minimal jurisdictional requirements, but it does apply to nonprofits. There's no exception for nonprofits of any kind. And so unless a very narrow exemption of some kind applies to you, this law is going to apply to you. You should assume it does. As it applies to employers across the country. The Fair Labor Standards Act is a big law. It's an important law. It's been around for a long time. It's one of our oldest labor laws, but it really doesn't cover very much. There's only a few things that fall under this law. One is that all employees that work for a covered employer, and again, 99% of employers are covered, have to make at least $7.25 per hour, which is the current minimum wage. So the law establishes a minimum wage, and it says all employers have to pay their employees at least that much per hour. In order to determine how much the employee is owed, of course, you're going to have to require the employees to track their time. So that's the second big requirement. All employees have to track their time accurately. Employees cannot be allowed to work off the clock. They should not be required to work off the clock or ever instructed to work when they're not writing down and recording their time. So minimum wage, record your time. And then if an employee works more than 40 hours in a 7-day work week, for all the hours over 40, they have to be paid time and a half their hourly rate for that week. That's really it. Those are the big 3 requirements of the Fair Labor Standards Act. There are a couple of child labor aspects, which we're not really going to get into. That's it. Minimum wage, record the time, time and a half overtime. And then everybody says, but wait, what about our salaried people? And that's really what this change is all about. The presumption is going to be that every one of your employees falls under those 3 requirements. That's the default assumption under federal law. If you can prove that your employee or a group of employees or a job position, if they are exempt from those 3 requirements, then you may not have to comply with those 3 requirements. Exemption is the word of the day. The burden's on you as the employer to prove an exemption applies so that you don't have to worry about time tracking and the other things on this slide. Great job, Natalie. So we're going to talk now about, well, what are those exemptions? Because again, that's where this change is going to apply. Certain employees are exempt from the timekeeping, minimum wage, and overtime requirements of the FLSA, which I just described. And so that sounds beautiful, right? Why wouldn't everybody be exempt? We don't want to have to track our time. We don't want to have to do math to figure out what people are owed, and it gets real complicated if anybody makes bonuses or gets incentive pay. I just want everybody to be exempt. So why can't all my employees be exempt? It's not so easy. In order to qualify for an exemption, certain strict statutory requirements must be met for each position. Remember this, your employees are going to be assumed to be non-exempt, and the burden's on you under the law to prove they are not, to prove they are the exception to the rule. All right, so we're working closer to actually telling you what the exemptions are and if they apply to your employees. The exemptions we're going to focus on today, because they are the subject of this new change, are called salaried exemptions. So we're getting to that word salary that everybody's thinking of, like, hey, I've got employees that are salaried, so I don't do all those things. The exemptions we're going to talk about today have 2 parts. You have to pay the employee on a salaried basis or a fee basis. We're not really going to talk about fee basis today because that's a little bit niche. We're going to talk about salary. And you have to pay them that salary at the federally required minimum amount each week. So on a salaried basis at the minimum amount. The minimum amount is the part that's going to change, we think, under the new law. That's what we're going to have to figure out by July 1st. But paying them on a salaried basis is not enough to establish the exemption. They also have to perform exempt duties. So 2 parts to an exemption: salaried basis of payment, exempt duties. What is salaried basis of payment? Salaried basis of payment means you guarantee that this employee is going to make at least the minimum threshold amount, if not more, and it's on a weekly basis without regard to quality or quantity of work. So we're not tracking your hours to decide how much you get paid. I promise and guarantee to you, you're going to get paid X on a weekly basis. A lot of these amounts that you see for the salary are annualized. I'm going to give you the annualized numbers as well, because we all kind of think in terms of an annual salary amount for our planning, for our budgetary purposes. Employees think about that as well. But just so you understand, the requirement is a weekly requirement. So if you pay an employee less on a weekly level sometimes, but it all ends up at the end of the year to add up to that annual amount or more, it's not going to be true salaried basis of payment. The salary test is a weekly guarantee, not an annual overall guarantee. Right now, it is $684 per week, which equates to, on an annualized basis, $35,568 per year. That's what it is right now, and that's what it's been since 2019, right? To put somebody under a salaried exemption right now, they have to be making guaranteed without being subject to deduction for time missed, and I'll explain that more in a bit, $684 per week. That's the big change. The upcoming changes only apply to the salaried exemptions, which we're going to talk more about, generally professional, executive, administrative, and computer. Next slide. All right, here's the change. This is what's changing. The Department of Labor put out a proposed new rule last year, got comments from everybody, went back and tinkered with it a little bit, and then a couple months ago, not a couple months ago, a few weeks ago, put out this new rule that is a final rule. On July 1st, 2024, that amount of $684 per week that's been in place since 2019 will increase to $844 per week. That equates to about a $44,000 a year annual salary, but remember, it's a weekly requirement. That would put that's based on the 20th percentile of what the workforce earns in the lowest earning demographic area of the country, which happens to be the South. I'll explain that more in a minute. This new rule is a two-phased increase. So as of July 1st, if you want to treat somebody as salaried exempt, you got to pay them at least $844 a week. Then on January 1st, 2025, that increases yet again to $1,128 per week, which equates to about $59,000 a year. Got the exact amount there on the slide. All right, that's what we're going to focus on today, sort of explaining what that means, what you need to do to comply, and whether we think it's actually going to go into effect as stated. There's something else called the highly compensated employee. We don't run across that many of these folks in the nonprofit world. We run across them more in the for-profit sector. But if you have an employee that earns a higher amount, currently it's about $107,000 a year, but it's going to increase to about $151,000 a year. And I'll explain to you what that highly compensated employee exemption is and what it means, but it's also going to increase July 1st. And then the other thing that's changing is that the new regulation states that this amount will automatically increase based on a certain index every 3 years, starting July 1st, 2027. So this 2025 number will be in effect until July 2027, and it's going to increase based on a bunch of factors every 3 years after that. So we were wondering if this lawsuit was going to be challenged. Well, it was. There was a lawsuit filed last week in the Eastern District of Texas. It was filed on May 28th. And that's really all that's happened at the moment. I actually looked online this morning, did my little Googling to see if there's anything new. It's pending in front of the judge. It's a bunch of business groups. It's like sort of chambers, organizations, and some industry groups who filed saying no, that the Department of Labor shouldn't be able to do this. They've exceeded their authority. They've raised the level too much. And the every 3 years automatic increase is something they don't have the authority to do. And particularly that next phase increase in January is way outside the bounds. So whether that will prevail remains to be seen. We'll talk about the history in a second. Things are a little different now than they were in 2016 when that increase at that time was struck down by the court. All right, so the bottom line is, yes, a lawsuit's been filed to challenge. That may go all the way to the Supreme Court. We don't know how it's going to turn out, but I think you guys don't have enough time to wait and see how it's going to turn out. Unfortunately, you really need to come up with a plan to get in compliance for that phase 1 increase on July 1st. So the next step for you all, and we'll talk more about this towards the end of the presentation, the next steps are going to be identify impacted workers. I'm sure most of you have already done that. Identify who is going to fall below the required amount, who you have classified as an exempt salaried employee. You need to come up with a plan for how to deal with that, which we're going to talk about. You need to have a plan for communication of what you're going to do to your workforce, training your supervisory staff. And as we're going to talk about, this is actually not a bad time to give yourself a full audit on these issues. So next slide. If anybody wants more information on this straight from the Department of Labor, there's the link. They have a whole site telling you all about this stuff. Next slide. All right, so this has now been challenged in the court. I remember back in 2016, I went around like a crazy woman, telling everybody how to change stuff. And then literally like 4 days before this was supposed to go into effect, the same court, the Eastern District of Texas, had a lawsuit filed just like now, and they issued an injunction from that rule going into effect. So we didn't, companies didn't know until just days and hours before the deadline that they weren't going to have to do the increase that was put in place at that time. And so a lot of people may think, oh, you know what, based on what happened in 2016, I'm not going to worry about it. I'm not going to do anything. I'm just going to trust that all this is going to get overturned. I really wouldn't be so sure. One thing is the 2016 increase was based on the 40th percentile of earnings of full-time salaried workers in the lowest wage earning region of the country, which is the South. That was deemed to be taking too big a bite, for employers to handle. That was enjoined, and that was right before the Obama administration went away and the Trump administration came in. And so the Trump administration just let it die. The Department of Justice normally would have appealed that from the Eastern District of Texas and the appellate court. But once the administration changed, obviously the Department of Justice didn't want to do that anymore. So they just let it die on the vine. Here, we're not that close to an administration change. And I think this thing may get all the way up to the Supreme Court before it's decided. And so even if it doesn't change in July, if an injunction's issued, it might go into effect in the fall in a slightly different form. Also, keep in mind that in 2019, under the Trump administration, they also put through an increase in the 20th percentile, and it was not challenged, and it went into effect. So we did get an increase 3 years later. It was just less of an increase. These current changes, the first one in July, it more aligns with that 2019 change. It's aligned with the 20th percentile. It's the January 1st change that's closer to that big leap that got struck down. The point of all this is, Kara doesn't have a crystal ball, but if Kara had some money to bet, which I don't, but if I did, I would bet that the July 1st increase is going to go into effect because it is reasonable compared to what was approved in the past. And any negative ruling will focus more on that January 1st second increase. Just a guess, don't know for sure. Okay, next slide. All right, so I've told you what's changed. What else has changed? Absolutely nothing has changed about wage and hour law except those numbers I just gave you. So that means that the duties test, like the kind of job duties these employees have to be exempt, that's not changed. It only affects exemptions where they have to be paid on a salaried basis. And there's a bunch of exemptions where that's not required, so those aren't affected. How you decide whether somebody's paid on a salaried basis, that hasn't changed. There are certain professionals that are exempt from the salaried basis requirements, lawyers for one, doctors for one, teachers for another. They're still exempt. You still don't have to pay them on a salary, and that hasn't changed. If you have non-exempt employees, the employees that you do have clocking in and clocking out, writing down their time, paying them hourly, the rules are exactly the same for all of those folks. If you have any independent contractors, those classification rules have not changed based on this law. And the Tennessee state law requirements about when you're required to pay somebody, notices about pay, final pay, none of that has changed. Next slide. So again, we're in this little sticky wicket of having this deadline on July 1st. That's a big deal. And I don't see any enforcement grace period being put into effect. I think there will, as a practical matter, be somewhat of a grace period, but it's not guaranteed. And yet you have this lawsuit pending where you're not sure exactly what's going to happen. But assuming that it goes into effect as stated on July 21st, anybody that you're not paying a salary at that new level will immediately fall into non-exempt status that day. You're not going to be paying them enough anymore to treat them as an exempt employee. And so you got to do something about that, because if they're not exempt, what does that mean? If you go back to the very first slide, which Natalie, you don't have to, but if you remember back to the very first slide, if they're not exempt, you should be tracking their time. You should be doing minimum wage checks, and you should be, most importantly, paying overtime if they work over 40 hours in a week. For exempt employees, remember, you just pay them a salary, and that covers all the hours worked. You don't have to worry about overtime. So that's the big difference between exempt and non-exempt. Somebody asked, what if they are exempt part-time employee? It doesn't matter whether they're full-time or part-time. If you're not paying them that guaranteed amount, you cannot treat them as exempt, period. Now, if they're really only working 20 hours a week, it shouldn't be a big deal because they're not working overtime. But you would have to think about putting them back into a non-exempt classification if they're not making that salary. In other words, there's no proration for part-time employees. I think that's the bottom line of that question. So you got two choices here with these folks. You can either reclassify them as non-exempt and pay them in that way with overtime, or you can raise their salary so it's above the required level. All right, but if you raise the salary so that they're above the required level, that's all well and good. That's the big question I get, which is, oh, so if we just raise the salary, we're fine to treat them as exempt. Well, yes, if they were correctly classified as exempt to begin with. In other words, if they're doing job duties and have a level of responsibility to qualify for exemption, and you're paying them on a salary that's below the level, then raising them above will be compliant. But if you have somebody that's not doing the job duties to be exempt, just raising them to that salary level is not going to be enough. So employment lawyers tend to be very gloomy and scary and see the dark side of everything. But there is a silver lining here, which is that in my experience, I don't think I've ever run across an organization of any kind that totally had everything together on their FLSA compliance. It's a really difficult, technical, non-intuitive law to comply with. So this, this change gets a lot of publicity, gets a big splash, employees sort of know about it. So this is really not a bad time to do a overall compliance review. And if you find any other little changes that need to be made that have nothing to do with this change in the law, but they're changes you probably should have made, a long time ago, you can sort of roll all of it out at the same time. And those kind of changes don't draw as much attention. Next slide. So to make sure you've got your employees correctly classified as exempt, just remember you have to make sure they're being paid the amount, but also the duties. And when I do this type of audit for a client, I always look at org charts, job descriptions, the salary ranges for each position. I talk to people, I observe what they're doing. Next slide. First of all, the salaried basis test is not just about the amount you pay, it's making sure you're paying them correctly on a true salaried basis. Again, it's a weekly amount, and it has to be a non-fluctuating amount, not subject to deductions based on the quality or quantity of work, with very limited exceptions. So basically, if you're paying folks on a salary, trying to treat them as exempt, if you're docking their pay for any reason, you really need to be careful about that and make sure you're allowed to do that under the law. Because if you illegally dock the pay of a salaried employee, you could lose the exemption. Remember, it's a guaranteed amount. And so if they take off half a day for some reason, and then you go in and not dock them half a day's pay, that's not salary basis of payment. Next slide. There are certain times you can dock the salary, and it's okay. And I've listed those on the slide. I don't think we need, in the interest of time, necessarily need to go over all of those. But the point being, if you're docking the pay of a salaried employee, just make sure you have the ability to do that under the law, or you could find yourself losing that exempt status, which means you may have an overtime violation and a timekeeping violation. Anytime a good rule of thumb that summarizes those slides is there's a lot of times that a full day docking is okay based on the limitations set forth here. Anytime you're docking the pay of a salaried employee for partial days, you really need to get some legal advice. Now, quick little note, making them use PTO time or pulling time from a sick pay or PTO bank or vacation bank is not the same as docking their pay. Two different issues. Where you get in trouble is when they don't have any paid leave, you don't have a paid leave program, or they don't qualify, or they've run through all their paid leave, and then you're docking their actual salary. That's a problem for your exempt status. Next slide. This is more just warning you not to dock pay, particularly for partial day absences. Next slide. All right, so the duties part. And again, as you're getting ready to tackle this big change coming up in July, as far as sorting your people out, giving them more pay, or knocking them back to not exempt, for anybody that you want to just bump up and keep as exempt under the new threshold, make sure that they're actually doing exempt job duties. Their primary job duty has to be exempt in nature. And primary means principal, main, major, or most important part. It's okay if the employee does some non-exempt job duties, but their primary duty has to be exempt in nature. And we'll talk about what that means. So look at the relative importance of the non-exempt versus the exempt duties. If they're doing non-exempt duties, is it once in a while or is it all the time? Generally, there's a 50% rule of thumb under federal law. If somebody's spending more than half their time doing just menial tasks, paperwork, manual labor, things that require no judgment, discretion, authority, or specialized skills, you may not be able to treat them as an exempt employee, even if you pay them at the requisite salary level. Next slide. I'm going to run quickly just through the exemptions that normally would apply in most nonprofit situations, and also which are affected by this change coming up July 1st. One is the executive exemption. In addition to paying them at the requisite amount on a salaried basis, they have to have a primary duty of management of an enterprise or a customarily recognized subdivision. The subdivision could be operational, like they run a department. It could be geographic, oh, they're over in this branch or this location in charge of it. Basically, they have to be the boss of whatever they're doing and have an area where they have authority to make decisions, to tell people what to do, and they have to supervise the work of 2 or more employees. So if they do those things and you pay them at the new salary level or above, you can classify them as exempt. Next slide. Administrative exemption is a very common one. It's also an easy one to get wrong because we have sort of the layperson's understanding of administrative work versus what the FLSA thinks is administrative work. Just because someone works in an office and sits at a computer and went to college doesn't mean that they qualify as an administrative employee. They have to be performing work related to the management of the business operations of the employer or the employer's customers, clients, whoever you serve, and it would be the nonprofit version of that. And they have to be doing things behind the scenes to make the business function and run. And they have to be using discretion and independent judgment with respect to matters of significance. So this exemption is not going to include routine clerical work. It's not going to apply to your lower level people who really have no decision-making authority and are just doing what they're told or following a preset list of instructions. Next slide. Learned professional is another exemption. It usually requires a higher or advanced degree that is used, needed, or required in the job. So if you could have a PhD, but if you're working, selling hamburgers at McDonald's, that doesn't mean you're a learned professional just because you have a PhD. You actually have to use it in your job. Sometimes you can substitute actual on-the-job learning and skill in certain kinds of professions. And again, also that salaried basis of payment is required at the level that's going to be in effect July 1st. Next slide. Creative professional are those whose primary duty requires invention or imagination in a recognized field or creative field or field of artistic endeavor. Also, they have the salary basis level requirement. Next slide. Computer professional exemption may apply. That it has two possible ways of paying those folks. You could either pay them salary at the new amount, or they can be paid hourly at $27.63. That hourly amount is not impacted by the upcoming changes. It remains the same. It's only the salary part. And this is a pretty narrow exemption. It definitely doesn't apply to anyone who uses a computer as part of their job, which we practically all do now. Next slide. Outside sales, it could apply to some development positions, maybe not, depends. But anyway, if any of you have this exemption in your organization, it's not impacted by this change at all because there's no salary basis requirement for this exemption. Next slide. All right, so for those of you who do have folks earning at that higher six-figure, level, this is a good exemption to take advantage of because it has a lower duties threshold. Okay, so you probably want to get some advice about this one. But remember, for this one, the amount is going up, like from $107,000 a year to $151,000 a year. Next slide. So why does all this matter? Well, of course, we all want to do the right thing by the law, but what happens if you don't is that you could get hit by a U.S. Department of Labor investigation or agency action, or somebody could file a lawsuit. That somebody is probably somebody that left your organization under bad or not great circumstances. That's almost always how it happens. They leave, they're angry, they want to sue you, they go to a lawyer, the lawyer asks questions about all that stuff I just talked about, and the lawyer says, I think they misclassified you as exempt. I think, how much did you work? Oh, I worked 80 hours a week. Oh, and you didn't get paid overtime. I see. So that's how it goes. The Department of Labor also could respond to a complaint. They'll come in, and anyone they find is misclassified as exempt, you've got to pay those folks any unpaid overtime at time and a half, their hourly rate at whatever amount of hours the court or the Department of Labor finds that they worked, which will be whatever they say they worked. And you usually won't be able to disprove it because you didn't keep time records because you treated them as exempt. Okay, so if you classified me as exempt and you didn't pay me overtime, I get mad, go to a lawyer. The lawyer says they misclassified you. They should have been paying you overtime. They should have been making you track your time. that person says they were working, 50, 60, 70 hours a week. No matter how nicely you treated them, no matter how generous their salary was, no matter how many perks you gave them, they will still get that time and a half as back pay and liquidated damages probably on top of that. So that's why this is more than just a hypothetical concern. This is my bread and butter, is defending companies, including nonprofits, that get these kind of lawsuits. Do it all day, every day. It happens. Next slide. All right. So to get ready for this change coming up in July, you need to identify impacted positions, review your options, and either increase salary or reclassify those folks as non-exempt employees. This is going to require maybe a thoughtful consideration of how much they're actually working. If you reclassify them to non-exempt, are you going to have a lot of overtime, or do you think you probably won't? If you're going to reclassify them as non-exempt, you need to try and figure out a fair hourly rate to try and get them back to where they were as a salaried employee in terms of overall earnings without going way over that because of time and a half overtime. So you really need to start working through those equations right now. Sometimes you have certain benefits that only exempt employees are eligible for, so you'll need to think about that. Anybody that you reclassify to non-exempt, you're going to need to train them on how to properly keep their time because they're not used to doing that. And incorrect timekeeping and off-the-clock work is a whole other realm of problems if they're not keeping their time correctly. If your issue is that you think you're going to see additional expenses when you start paying these, I usually see two problems. One is when you take an exempt salaried employee who's worked in a very loose and forgiving environment and you reclassify them so they only get paid for how much they work, all of a sudden you find they're only working 28 hours a week. And that I definitely have seen that happen, and that's a problem. You find that they're underemployed and that you're going to be paying them a lot less than they were when they were salaried. The other issue is they really were working 50 hours a week the whole time. And so now you're going to have to start paying them time and a half for that. And how do you calibrate so that your budget cost is roughly equivalent? You can control overtime by hiring part-time folks. You can control overtime by telling people that they shouldn't, that they're not allowed to work overtime without permission. All of those things are possible. What you can't do is you can't let people work off the clock because you don't have the money to pay them the overtime. That's illegal whether they agree to it or not. Next slide. If you want to do full exemption audit, here's sort of your checklist. I think we've gone over a lot of this already. Make sure you're doing salary basis of payment correctly with no proper deductions, and make sure the folks you want to keep as exempt are actually doing exempt job duties at the required level of responsibility, authority, judgment, all the factors that were on those slides. A lot of them are easy to figure out, but some of them aren't. It's a close call type situation. That's where you might want to get some advice from outside counsel on those. One idea people have is, oh, maybe I'll just make everyone an independent contractor. Please don't do that. That's an even worse world of pain in terms of compliance issues. For another day, we can talk about. Next slide. Again, you have your work cut out for you between now and July 1st. But if having gone through these slides, you realize you maybe got some oopsies here and there that you need to fix in addition to dealing with this change, I would try and do it all at the same time because the oopsies won't draw as much attention if they're under the guise of, well, the government changed the law, and so that's why we're doing it. It's a good time to clean house, to look under the rug, see what's there, fix it. Keep communications open with your employees. Train your supervisors on how to, route questions on these issues. Make sure the questions are being answered by people that actually know the law and know what's going on. And train people who are being classified as non-exempt on how to properly record their time. Next slide. Anyone that you reclassify as non-exempt sometimes will feel they've been demoted. You really just need to explain to them you're just complying with the law and it's no reflection on how great of a job they've done or how you think of them. We talked about reconfiguring your benefits eligibility requirements if you need to. Give it some thought. If you're seeing increased overtime costs as a result of reclassification, get your arms around how to control that. There's lots of legal ways to control overtime. And we talked about the no on independent contractor classification. Next slide. Make sure everybody who's not exempt is accurately keeping their time. If you don't know what that means, if you don't know what is work time versus not, and I'm talking about remote work, travel time, meetings, conferences people go to, that's a practical issue that comes up. If you have someone who is classified as salaried exempt, you don't have to worry about paying them to go to a conference or to drive somewhere, you know, to do part of their job because it's all inclusive in the salary. When you kick them back over to non-exempt status, you've got to figure out which of that time is compensable work time that they have to record. So you may need to get some advice on that if you haven't dealt with that issue before. Next slide. Now, I was trying to get through the materials and I didn't really hit on every question. How would you guys like me to handle questions?
So we've had a couple questions in the chat. So Kara, I'll go ahead and stop sharing and lift up some of the questions that have been asked. So I'll start kind of at the beginning and then just work my way down. But our first question for you is, do salaried employees working full-time but less than 40 hours a week have to make them new minimums by July 1st?
Yes. The amount of time they work is irrelevant. If you've classified them as salaried exempt and you want to continue to treat them like that after July 1st, and assuming the law doesn't get struck down before July 1st, you're going to have to increase their salary to that level.
The next one was, please explain if teachers are exempt from this rule if currently paid on a salary.
Yeah. Teachers are an exception. You don't actually have to pay them on a salary. And if you do, it's not impacted by this change.
So one of the questions is, what's the dollar amount starting July 1st for weekly pay? And then is that assumed to be pre-tax?
It's definitely pre-tax. It's a gross amount. And it is it 844? It's on the slide. I think it's 844.
Yes. Double checking, but yes.
I don't have them memorized yet, if you can believe it.
No worries. It's a tough one. The next one is, okay. So if your employees don't work overtime, what is the employer's incentive to classify positions as exempt? So no overtime, but why do we do exemptions?
Okay, so if none of them work overtime, then classifying them as exempt really doesn't have an advantage for you as the employer. Because the only time overtime is due is if they work over 40 hours a week.
Perfect. Well, kind of a similar question, but on the flip side, can we just pay exempt individuals overtime if they work overtime?
Okay, if they qualify for exempt status, which means you're paying them over $844 a week. We're just assuming that rule goes into effect. And they have exempt job duties, then you don't have to pay them overtime regardless of how much they work. And the other thing is, when they're in exempt status, you don't require them to record their time. There's no requirement that they write down their time. So really, if they're exempt, you don't often know how much they're working. If they are non-exempt, they have to record their time. And you will then know each and every week if they're paid, if they work over 40, and it's only then that you have to pay them over 40. Now, it's kind of a complicated concept here that may go beyond this session and maybe something people want to get specific advice on. You can pay non-exempt employees on a salary. You don't have to pay them hourly, but you still have to record their time. And if they work over 40 hours in a week, you have to figure out what their hourly rate was that week and pay them time and a half that. So I wish I had a slide with a little math problem, but I can pay you, $750 a week. And so, 1 week you work 38, all you get is the $750 a week. But if 1 week you work 45, I got to divide 45 into 750 to figure out your hourly rate. And you get time and a half that for all those hours over 40 on top of your $750 hour. Got it?
Kara, this is Sherry Campbell from Chattanooga. That's what we've been doing.
Yeah.
So if I have an exempt employee and they work maybe a Saturday at an event or something, and they've already done their 40 hours, then we add 8 hours of overtime. So they're not making the 844 maybe a week, but they do get paid. I make sure that they get paid overtime if they go over 40 hours.
Yeah, you're getting into some specifics that we'd probably need to talk offline about. Okay. But if you have exempt employees that meet all the duties requirements and you're paying them a guaranteed salary every week, it's okay to give them extra on top of that. It's not illegal to pay exempt employees overtime on top of their guaranteed salary. Now, if you rig it so their guaranteed salary is like a fraction of their overall pay, it's going to look like you're evading the requirements of the law. So be careful. But if you have an employee that's otherwise correctly classified and paid as an exempt employee, and you want to give them extra pay as an incentive or a reward, whether that's hourly overtime, whether it's a bonus, whether it's additional comp time off, all that's okay.
So the next question is, are there any nonprofits that are not covered by FLSA? For example, small nonprofits that do not generate annual gross volume of sales and do not engage in commercial activities.
It's theoretically possible if you don't have a certain level of revenue generated, or once in a while I run across an entity that literally does absolutely nothing outside of its state. Because to have jurisdiction, you have to be working in interstate commerce. Now, if you buy copy paper from California, or if you make phone calls to people that live in Kentucky, you're doing business in interstate commerce. So it's in this day and age, it's virtually impossible to not be in interstate commerce. But if you feel like you're below those minimal threshold levels to be under the FLSA, I would make very, very sure you're correct. And I would get a qualified outside legal counsel to look at that, because assuming you're not under the FLSA and finding out you are is a very problematic. But it's not impossible.
Next question, as the owner founder of a nonprofit, are you exempt from these regulations?
There is an exemption for owners, yes, if you own a certain percentage of the company.
Then we have kind of a potentially specific one, but it may apply broadly to the nonprofits on this call. By
the way, I'm giving you hypotheticals. Anybody out there who's trying to act in a way where you're not putting yourself under the FLSA, regardless of what Kara says on this webinar, you need to run it by and get some specific legal advice. Because if we aren't connecting on the details, and I'm speaking hypothetically and you're relying on what I'm saying, I don't want you to do that. I want you to make sure you're right.
Yes, all hypotheticals here. On that note, so someone has heard where for social workers that social workers can never be exempt unless they have a master's degree. This feels very niche, but have you heard anything?
Yeah, that's a really specific question. I'll be honest, I have looked at it before because I do represent nonprofits, and there's never a never in FLSA. I think that sounds like a plausible theory, but I'm not 100% sure if it would be correct in every situation.
Okay, so maybe further information needed on that one.
Yes, and also these things change. I think I looked into that maybe 5 or 6 years ago, and I haven't looked at it since. So I don't know if anything's changed in that regard. Courts are coming out with new decisions all the time.
Perfect. And then, so we've got 4 minutes left. Oh my goodness. I'm going to move through that one. So do we as nonprofits have to file official paperwork to FLSA to classify an employee as exempt? Or is
No.
that something
Nope.
internal? Okay.
Nope. You just do that internally, and then the fun part comes if you're audited. Then they'll say, prove why this person's exempt. So you want to keep your documentation on, on hand, but no, you don't have to file anything with the government.
Another clarification, all of the exemptions that we went through, highly compensated employees, all the other exemptions, all of that is still effective July 1st, 2024.
Yes. None of the duties have changed. None of the classifications have changed. The only thing's changed is that salary number you have to hit.
Excellent. And then, okay, so just hypothetically, what are your thoughts on making salaried exempt employees still track time? So it's just across the board, whether you're exempt or not exempt, we're tracking time.
You know what? I'm okay with it. That's perfectly legal to do. You're allowed to make everybody track time. It has saved employers in some situations where somebody was wanting to claim they worked a lot more than they actually did. And the employer said, no, because we actually have your time. Now, if you're going to do that, I will give you a cautionary note. If you're making somebody record their time, but that person knows they're not getting paid based off what they write down, there's a psychological tendency for them to be not as accurate about it. So if you're going to make your exempt employees record their time, please be sure they're doing so accurately and not just dashing off 8 to 4 every day or 9 to 5.
Got it. And I think we have time for just one last question, and we'll go with the volunteers because I know we have a lot of volunteers.
And honestly, that's a good way sometimes to figure out how much people are working for planning purposes if you're getting them to do it accurately. And sometimes you need to do it for like a grant or, like if you're wanting to add more staffing or something. There's lots of reasons to do it other than FLSA. Next, I'm sorry, I interrupted you, Natalie.
No, you're all fine. Just making sure that was for track time. So last question, can managing volunteers be seen as, so volunteers, can they be seen as employees if a lot of them are spending a lot of time at the organization, or does all of this only apply to full-time employees only?
Okay, that's a beautiful question that I knew would come up with nonprofits. These rules only apply to employees. So if they're not on your payroll and you're not paying them and you're treating them as volunteers and they are legally entitled to be treated as volunteers, none of this would apply. The magic question, though, is has a line been crossed? Because if someone's not truly a volunteer under the way the law defines that, then they're an employee. And if they're an employee, these things would apply to them. So the issue really is make sure that any interns or volunteers or people that you're not paying and treating as employees meet the criteria to be unpaid. And that's a whole other topic, which I don't have time to get into.
Sounds good. Well, speaking of out of time, Kara, thank you for making time to meet with us and presenting all of this information to all of our members. If we missed your question, I am so sorry. I know we have time is short, but there's plenty of information. All of this information will be shared out with emails following this. But Kara, thank you again for joining us and being so gracious with your information and knowledge.
I appreciate it. I'm happy to help. And if anybody actually needs a lawyer to work through any of this, Natalie knows where to find me.
Yes, please reach out. So thanks, everyone. Take care.